All right, I apologize there. I had a little technical difficulty at the beginning there. I didn't even it locked me up. I didn't even realize I was live. So I apologize for for the 4 minute intro screen. But anyways, we're live tonight because we got cut off on the last hour of court. So I'm going to run that. I had to step out of the studio and it cuts off at 6 hours. So we got cut off. Normally I'll try to cut it up so that doesn't happen if I have to step out or leave or run an errand. But we're going to go ahead and run that down. It's not much exciting stuff. It's just the last hour of them discussing and going over instructions. But you never know. Sometimes important things happen, and we want to be aware of that and be watching that. So let's pull that up, jump into the courtroom, and start watching. All right, so we've got it pulled up here. Let's go ahead and pick it up. And this is picking up from when it cut off. We were on a break. So this is going to pick up after that break resumed. No need to wait out the break there. And here we go.
Good afternoon. I'm back.
Good afternoon, Judge.
How are things shaping up?
I think we have everything in order, Judge. We just emailed Ms. Violet one sheet of paper that we need to just insert in each packet, and we're good to go.
You need 3 copies of it?
Yes, ma'am.
Judge Jones, just so the court's aware, part of the problem was some of these instructions changed in December, but evidently the website hasn't updated. You have to go to a different location to find the update, so we weren't aware of that until today.
I understand instructions are rarely easy.
Well, we were informed, Judge, that I guess the principal instruction changed in December of 23. We had actually included the one off the website, which ASA Britt brought to our attention. He said that's the old instruction, so what is this?
Well, my book, the instruction coincided with what your initial proposal was.
I go to the judge? Go to the judge. All right. Yeah, Judge, our book as well, but evidently the books aren't reflecting the December changes.
Thank you. So Mr. Tucker has a copy here.
Not yet, but I'm sure they're going
I'm going to give it to him right now, Your Honor.
Is this it right here?
That's our copy.
Thank you, that's okay.
No, I like the fat one. I'm just kidding.
Thank you, sir.
So most of these are going to be identical to what we reviewed previously with some of the cosmetic changes and
Exactly, Judge.
other changes, and apparently the only big change is the new principal instruction.
Well, the principal, and I remember I omitted Agasol. I
right.
have that in as well.
All right, so let's systematically go through these. 3.1, Introduction to Final Instructions. 1.6, Pro Se Defendant. 3.2, Statement of the Charges. Introduction to Homicide, 7.1. Okay, unfortunately, the package I have still sees in the brackets in 7.1.
Me too, Your
And the manslaughter too.
You can printed out the wrong one, Judge. We have a corrected version right here. We'll send a copy to Ms. Violet. Or I can print them out at the office, Judge.
No, if the clerk doesn't mind helping out here, anything we can do to accomplish this now would be appreciated. We had taken out parentheses, crime charge, brackets, or third-degree murder, more manslaughter, all that had been agreed to be removed.
Actually, we just need 2 copies, Judge. Here's a corrected version that I'll give you for your honor. And I'll replace the 2 copies in my packet, Mr. Tucker's.
You sent something?
Yeah, it's 7.1, just 2 copies.
These definitely feel small.
Well, I'll wait till you get yours, but the one I've been handed does appear to be what we agreed upon earlier.
Oh, okay, oh, to make a copy, now we'll have to scan it or. Okay. I'm just waiting for something. Judge, could we see your copy? We'll go ahead, it hasn't come through the email, we'll just scan it here.
Just make it.
Oh, here it is now, okay.
Okay.
Okay, thank you.
Okay, so is there any objection to the modified 7.1?
Take a look.
I can already see problems with the 3.5.
I gotta say, because I'm looking at it, Your Honor, my copy of 7.1 still has the brackets. I mean, let me make sure I didn't accidentally put the other one over here.
Well,
Is your bracket? The one that I handed up to the court, Judge, doesn't have any brackets,
No, I
and
think-
neither does the state's.
I think I accidentally put the other one back in.
Okay.
All right, so this one doesn't have the, this one doesn't have the brackets. Okay, let's get this over here. Just get it away from me. All right. All right, so back to this,
all right, so the 7.1 now is in compliance with what modifications that I agreed to or ordered be made.
Yes, sir.
There's nothing new in this one, right, Your Honor?
Right, it's just the fact that the brackets and the parentheses and the manslaughter was all removed, were all removed. So, but now the 3.5A, the principal instruction, apparently, there's been a change in the law effective, what, January 1st or December 31st, whatever the case may be is. And so this is the one that is now in effect, which is something that we didn't realize when we did the earlier charge conference. Okay, so I'm looking at the last paragraph here. It is not necessary for a principal to know every detail of how a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery will be committed. So I take it those are the lists of the charges in this case.
That is correct, including the lessers.
Right. Then, unfortunately, I see in the 5th sentence from the bottom, did help the parentheses name of crime occur. And you see there's parentheses and it says name of crime and there's not any crime.
Right, Judge, I'm sorry, all those crimes have to be repeated. Where it says name of crime, that list has to be inserted there.
We're making corrections as we speak, Judge.
Follow what I'm saying? Okay.
I'm just also curious where this principal instruction is inserted. We're putting it right after the introduction to homicide. I didn't think that was where it was in the initial package. Not that that's etched in stone, but I wouldn't think it goes right after 7.1. One step at a time.
Judge, the thing is, it applies to every crime, so I don't know if we put it in the very beginning, or should we put it after, before all the crimes are, before they get the instruction as to each and every crime. I think the principal should maybe be the first thing they see before they go into each and every crime.
I understand that has some logic to it.
Okay. That list has to go in everywhere it says name of crime, that list has to go. You got the other four?
It's a good thing we sent the jurors home. No, not yet. She's doing it now, David.
Anna, if I might. The thing I'm a little bit dismayed by is that, I remember Mr. Mansfield has already explained the principal theory to the jury using the old one. I'm not so sure. This one seems a little different. I'm not so sure how that applies.
And Judge, what I read to the jury was number 1 and number 2 at the top. All the stuff at the bottom is what's changed. What I read to them is it's not inaccurate. It's not a complete recitation of the instruction, but I made my point with numbers 1 and 2. The jury will get the complete instruction. It should have no bearing on it.
I honestly don't remember exactly, Your Honor, so I can't say otherwise.
Well, I trust that Mr. Mansfield, as an officer of the court, would be, accurately reiterating what transpired, number one. Number two, I feel that if the instruction has changed, which it has, then I'm obliged to give the most recent one. And number three, ultimately, the judge gives the law. So it's not unusual for attorneys to, argue the law, but ultimately the law comes from the judge, and whatever the attorney may have said as to his or her understanding isn't binding unless there was some deliberate misstatement, which there wasn't. I don't believe that it would.
I'm not saying there was, Your Honor. I wasn't accusing anybody of anything.
No, I know.
I just want to make sure that we didn't confuse them or anything like that.
I'm not saying that you're accusing anybody of anything. You bring up a valid point. Ideally, we should have had this beforehand.
I'm sorry.
We didn't. I don't believe anyone is prejudiced by virtue of it being changed to the most recent one from what we thought was the law previously. I don't think Mr. Mansfield's recitation of certain parts of it was misleading or a misstatement, and ultimately all I'm trying to do is make it clear that the law that I instruct upon and also I'm going to give them is really what counts in terms of what's applied. So I understand your point. I don't think it's a bad point, but I don't think it's going to jeopardize the fairness of the proceedings.
Okay. I just thought I'd bring it up, Your Honor.
Well, that's fine. That's why we do these charge conferences. Any other input on this principal instruction?
No, other than that, I don't see anything that highlights anything or that makes it, makes it.
Me neither. So then the question becomes, where do we insert it in this litany of instructions? So I don't necessarily think it's necessary to read it 4 times. I think 1 time is
I agree, Judge.
I would agree, Your Honor.
adequate. So then, it could be, right after the statement of the charge is one place to do it.
Judge, that would be the state's position, because that's right before we start going into the charges.
Statement of the charge, 3.2, 3.5A, principles.
Hey, guys, I would agree, Your Honor.
Thank you. Felony murder, 7.3.
I don't see any problems.
Thank you, I don't either. Robbery, okay. So robbery 15.1. So we've changed now because previously I thought the charge was robbery with a deadly weapon while masked, so now it's just plain vanilla robbery?
Judge, I had a note, I thought you had indicated, or I thought we as a group indicated we were just gonna go with robbery, isn't that correct?
No, that's not what I understood, that they want robbery with the deadly weapon and robbery with the weapon, and Mr. Mansfield said, we're not gonna seek plain robbery as a lesser. That's where we left that off. It was robbery with the deadly weapon, robbery with the weapon, no robbery. Initially, the request was robbery as a lesser included, then Mr. Mansfield, right, you said
Sir,
the
that's correct.
state's not seeking
Yes.
robbery.
Yep, that's correct.
Hold on, I actually got it.
Oh,
There you go.
Thank you.
But wait a minute. Is this just, so this one's just part of the felony murder instruction then? Oh,
And then this is the robbery with a weapon.
okay.
Correct, it also has the quotation.
So maybe maybe I'm the one who's getting ahead of myself then.
That's, Judge, I'm sorry, you're absolutely correct. The one that you're looking at is the underlying charge for the felony murder charge.
Right, so that was the qualifying offense.
Yes, sir, that's correct.
Wait, so we're getting rid of robbery and keeping robbery?
Yeah, but robbery stays
Oh.
here because my mistake, I assumed it was moving on to count 2, whereas it's part of the felony murder element. They have to find the robbery, so therefore this belongs there.
Judge, I would point out, I'm looking at the robbery instruction on the second page. I believe we just need to make one correction to the great bodily harm definition. It needs to have quotation in the front.
I don't know what happened here. A lot of these corrections we talked about haven't been made. I mean, robbery, there's the brackets again. And the,
This is robbery with a weapon.
let's go to the robbery as part of the felony murder. That we were gonna take the brackets off, this paragraph starting with the third sentence, the law does not require, there's the brackets. And we're gonna take ours.
Yes, ma'am. Your Honor, Your Honor, if
Yes, sir.
I might, I'm pulling up, because since we had there's some new versions of the stipulation, or I'm sorry, new versions of the jury instructions, and I'm looking at some of them that may or may not need to be included in here. I'm looking at the definition of accomplice. I'm looking at the weighing of the evidence. There's new ones on both of those.
We already have weighing the evidence, that's,
I just don't know if we have the new version or we have the old version.
I don't know, but, I asked earlier about any specials or additionals, and I'll certainly readdress it. Right now, I just want to readdress the things that we talked about the last time that haven't been fixed.
Yeah, I'm sorry, Your Honor.
That's all right.
I figured I'd look up the new stuff since we were adding the new version of that one. I figured there might be new versions of the other ones. That's all. Because just like Mr. Mansfield and Mr. Alvarez, I was going off of the old stuff too, so.
Do we see where I'm talking about?
Yes, Judge, we've already corrected it and we're sending it over to Ms. Byler right now.
The trouble is, the second page, there's a problem on the last sentence with the same brackets, used or threatened to be used or intended to be used. All that bracketed material hasn't been, the brackets haven't been removed. On the second page of
I
the
see,
robbery.
Judge, ours has been corrected as well.
Gentlemen, are we using the new version of felony murder too, or the old one? Okay, just want to check.
What is trouble?
It's now printed to 9:10. You want one for the beach?
I don't see anything there. Thank you, sir.
Okay, that one looks clean. Legally interlocking counts. Looks like the word one has been replaced with the number one.
I think we're good there, yeah.
When there are lesser included crimes or attempts, 3.4. We've got the second degree murder, not the manslaughter. 7.4, murder second degree.
Yeah, I think we're good on that. I didn't see anything on it.
You're talking about 7.4 now?
Yes, sir. I didn't see anything in there.
Let me just look at something here. Yep, all right. Aggravated assault, 8.2. See something that looks a little strange.
I did catch it just now, Judge. We're making the correction. We're taking out the A.
4 with a lowercase a next to it.
That should have been there.
Yeah, it should just be the assault was made with a deadly weapon. And then I also see victim in parentheses without the name. If you look at the paragraph immediately below 4A, or 4, look at the third line, actual fear on the part of parentheses victim. See that?
Yes, sir.
We modifying that ag assault?
Yes, Judge, it's been said. So just,
It's been set up here? You don't have it yet? No? Here it comes now. May I have some more water, please?
That's it. You still dictated that one. And which one's replacing? That's 8.2 ag.
Well, you've taken the A out, the alignment is just one space off, but I don't think that's substantive in nature.
Nothing.
You can see that the is one space to the right of the other does, but like I said, that is not a reason to redo it. But the A has been removed, so. Any objection to this?
No, sir.
Okay. So now, battery, that was fine the first time around. Aggravation of robbery by carrying a knife. Aggravation of felony by wearing a hood, mask, or other device to conceal identity. Three point seven, plea of not guilty, reasonable doubt, and burden of proof. 3.9, weighing the evidence. Mr. Tucker, you were mentioning something about,
I actually looked at it, Your Honor, and it seems like the state has already gotten the new revised version of 3.9.
okay. Rules for deliberation, 3.10. I see a bracket number 2 here, partial bracket, 3.10, paragraph 2, third line, exhibits and evidence bracket.
I actually have two brackets in mine, Your Honor.
Oh, you're right. In the line 2, and have seen in the form of exhibits and evidence. There are exhibits and evidence, and so that would certainly not be bracketed. So you see that?
yes, Judge.
We have to eliminate that. Oh, wow. My packet, I'm sorry, once we get done with this, doesn't include the robbery with a deadly weapon or robbery with the weapon. The packet I was given up here doesn't include the robbery with a deadly weapon. Now, you did put the robbery with the weapon up here, but I don't have the robbery with a deadly weapon in my.
Judge, it's contained within that one. If you look at the top of the second page, it says, if you find that the robbery was committed with a knife, then you should find that it was committed with as a deadly weapon.
I'm sorry. I guess I shouldn't skip ahead or skip behind.
Okay. The robbery with the weapon instruction, do you have that one, Your Honor?
I do.
At the top of the second page,
Yeah.
it basically incorporates deadly weapon as part of this instruction.
So again, let's do 3.10, and then we'll go back to this, because that's a different approach than what we discussed earlier.
Okay.
May be accurate, but it's different.
So we're on 3.10, Your Honor?
Yes, we are.
Rules for deliberation.
Yeah. Yeah.
We're taking the brackets out right now.
Okay. So we're waiting to receive that revised one by email?
Is it the 8.2?
No, it's the 3.10.
Yeah, that's the last one.
Send it over right now.
Did you send that email? Okay.
David, what are you guys working on?
Sure is taking a long time to Okay, I don't know what's going on here. Huh? Oh, okay, it's coming through now. Of course, the ink is much darker, but I guess that doesn't matter, but,
Judge, on this one, most of the ones on the Supreme Court website are already bold. I was emboldened them. I can unbold it for you.
it's all right. It's all right. I just, again, make observations.
Thank you, sir. Yes, we're good on this one.
Okay.
Should be good on this one.
Another one coming through? What is that? What's coming through?
Judge, I noticed on 3.13, which is the last
We haven't
instruction,
gotten to it yet.
we just sent it.
Actually, I'm looking at 3.10 still, and it came out all in bold. I don't know if you want that, Your Honor.
Well, it's darker than some of the others, but I don't
don't
believe, you know.
I don't see where it's a bad thing.
No, I don't think anything is going to be highlighted to the exclusion of something else, but I did see the same thing. But the problem has been corrected.
Just the last correction that the state will be making is on 3.13, submitting the case to the jury. If you go down to the bottom of the page where it says A.
Haven't gotten to it yet.
I was going back to robbery because in my packet, I didn't have outside of the felony murder robbery, I didn't have a separate robbery charge. You handed, you brought it up to the bench, but what the original packet had was robbery with a deadly weapon, then robbery with a weapon. We had two separate instructions, is my recollection, and now all we have is robbery with a weapon, so
15.1.
the, so the original package. Oh, this is getting. I think we need to go back because I'm seeing some discrepancies between the original submission and this submission. So let's just go back. this package, after second-degree murder, it goes right to aggravated assault.
Correct, Judge, you're missing something for robbery with a deadly weapon.
Well, here's robbery with a weapon, and maybe that's what we had to begin with, but then there were other instructions you also had originally. Oh, wow.
Your Honor, do you have 15.1 robbery with a weapon?
I do.
Okay, and I think that addresses the finding of a deadly weapon on page 2.
Fair enough,
So that might be the instruction that is needed there.
fair enough. But what about this aggravation of robbery by carrying a knife?
That appears later in the packet, I think.
It does? Not in the package that I've been given.
3.3A.
Mr. Tucker, you have 3.3.
That's what I'm looking at right now. You should,
Aggravation of robbery by committing an aggravated battery, 3.3C.
that's what I have.
Do you have it there, Mr. Tucker?
No, I'm looking, I've got robbery with a weapon. And then on the second page, yes, Mr. Mansfield is correct. On the second page, it says, if you find the defendant and his or accomplice carried a knife in the course of committing the robbery, and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. I think the rest of those are fine, I think.
Judge, which is the one you're saying you don't have?
In the original package,
We have, you wanna go,
So I have robbery with a weapon and robbery.
yeah, we have robbery with a weapon, and then, as
I
Mr.
had aggravation of a robbery by committing an aggravated battery. I had aggravation of a robbery by carrying a knife. I don't,
I think, Judge, we took that aggravation.
The aggravation with the knife is still in there.
Yes.
I do have
it's
a-
not in the package that I was handed, so I'm just trying to,
You don't have this one, Your Honor?
Mr. Mansfield.
not in the latest package, it was in the original
Same as
package.
robbery.
Aggravation of robbery by carrying a knife. Okay,
I think you have that.
huh?
You have that in the second package that they gave you?
No,
No, what I'm saying.
no, I don't.
Okay, then it must have been on.
I don't have aggravation of robbery by committing an aggravated battery.
Right, I think we decided we wanted to take that one out.
Okay,
Just make sure, Mr. Field, we want to take this one out, right? This is the one we discussed? Okay.
Yeah, Judge, there's enough interrogatories for the jury that this is not gonna have any impact
well,
whatsoever.
that's fine, but nobody told me until I noticed it was missing. So, I'm assuming the defendant is not objecting to taking away aggravation of robbery, by
Have it over here.
by committing an aggravated battery.
No, I'm not objecting to
Okay.
that at all, Your Honor.
All right, fine. So then, what we need is 15.1 and 3.3A, right?
Yes, sir.
Okay,
15.1 is robbery with robbery with a weapon. 3.3A is the aggravation for the,
okay. All right.
what was it, aggravation for what?
All right, so now we can go back to where we left off, and
I have a cautionary instructions. Right?
cautionary instruction, 3.11. Verdict, 3.12. 3.12A, single defendant, multiple counts or informations. Submitting case to jury, 3.13, but the The verdict, huh?
But they just sent a new one.
Okay, what was the, oh, I see some brackets here that are in the, so they corrected that one?
Yes.
And,
Copies are up here.
Oh, perfect. I was just flipping that.
now, so,
Looks good.
Mr. Tucker, was there anything else that you were requesting now? I know you mentioned something earlier.
No, I mean, you know, that was the one, the state already got the new version in there, so
Okay.
it's fine.
Okay, so now what I'd like to do is start from the top and just go through these again, so we're all on the same page. 3.1, 1.6, 3.2, 3.5A, principles, newest version.
Hold on. 3.15A?
No, 3.5A. If I said 1, I misspoke. 3.5.
Goes right to 7.1, the introduction of homicide.
No, you should have after,
So on.
we agreed that, you agreed to this as well, that right after the statement of the charges, we would then read the principal instruction 3.5A.
Just out of order,
Okay, all right. All right, so then we're on to 7.1, introduction to homicide. Felony murder, 7.3, first degree. Robbery, 15.1. Three point 12D, legally interlocking counts.
We're keeping robbery with a weapon though, aren't we, sir?
It comes
When we
later.
get to that point, that robbery was included in the felony murder instruction because they have to find one of the qualifying offenses, so. After robbery,
Interlocking.
3.12D, legally interlocking counts. 3.4, when there are lesser included crimes or attempts. 7.4, murder second degree. 15.1, robbery with a weapon. 3.3A, aggravation of robbery by carrying a knife. No, it's a separate enumerated instruction. Okay. State you're with us here. 3.3A, aggravation of robbery by carrying a knife. 8.2, aggravated assault. 8.3, battery. You don't have battery. Well, that's not good.
Are you sure you don't have it, maybe like in the other?
Looking right now.
Yeah, I'll skip Mars.
Still get mark copy, Judge, and we'll just.
Well, I probably, from the last package, I probably,
You gave Mark a copy.
Yeah, they gave me a copy, Your Honor, and it looked fine.
so then 3.3E, aggravation of a felony by wearing a hood, mask, or other device to conceal identity.
Yes, sir, I got it.
You got that, State?
Yes, Your Honor.
Hood, mask, or other device to conceal identity. Got it.
3.7, plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir.
3.9, weighing the evidence. 3.10, rules for deliberation. 3.11, cautionary instruction. 3.12, verdict. This is where the verdict forms should be inserted then. This is when I read the verdict forms. So, excuse me? Yeah, but before we get to that, this is where the judge reads the verdict forms. Once I get to the end of 3.12, it says the necessary verdict forms have been prepared for you. And then I take these and they say they are as follows, and I display them and I go just systematically through explaining the format, reading the words. So I take it there wasn't any change we were looking for previously with the verdict form, and they're basically unaltered, so. Count 1, count 2, count 3, and count 4. So, okay, so if I insert those at this point, then I go to 3.12A, single defendant, multiple counts or informations. You're with us, Mr. Alvarez? Yes, sir. Okay. 3.13, submitting case to jury. Yeah, that's what I got. Okay, State?
Yes, sir.
Yes, sir.
We are on board.
All right, so you're gonna make another copy of the battery for yourself?
Yes,
This is my copy, this is what I will instruct from, and this is what will go back to the jury.
Perfect. Yes, sir.
According to your list.
So I've had my assistant have the inmate plea docket set till 10 o'clock. So I certainly don't anticipate this taking any rush beyond 10 o'clock. If it does, obviously the other docket will wait. But what I expect is that we'll instruct them, we'll excuse the alternates, we'll send the jurors back to deliberate. Now, we'll have to discuss, is this whole unit going back there in terms of how is that gonna be done? That's always a point.
Well, Judge, you know, there's no reason why I couldn't. I think the thumb drives are pretty easy to put in. If we can figure it out, I'm sure they'll be okay with it.
Your Honor, I would prefer all the evidence go back there, so yes.
Yeah, that's the plan. I'm just saying that I just want to pay attention to all the details that normally we all concur. And in this instance, that can be wheeled back, and if they have any questions, I can certainly ask me, but it should be fairly simplistic.
Get in touch with Carrie to make sure that its internet functions are turned off, so all it can do is just play videos.
So I don't know if he's here now, or if not, we'll get him tomorrow morning. So otherwise, once we finish, we send excuse the alternates, give the jurors the evidence, the jury instructions, the verdict forms, and then basically they're deliberating. At some point in time, depending on how long it goes, we routinely would offer them lunch. There's a fund at the clerk's office, and if it gets close to noon or a little before, I'll ask Deputy Riccio to provide menus, and there's they can order, and the food will be delivered. As I said, it's from a separate fund. They're not buying their own lunch, and it's delivered, and they can eat while they're deliberating. Okay, well, he'll probably be tomorrow, or we'll get one of the other assistants. And I'll be up here on the bench, basically handling pleas and sentences, and if there's a question or a problem, or when there's a verdict, and if it's in the morning and I'm still doing court, I'll just cease what I'm doing and shift gears. So I don't see any problem in kind of doing those things while the jury's deliberating.
Yes, sir.
And sir, where would you like me to wait while I'm waiting for the verdicts?
Where?
Yeah. I mean, is there a specific place or?
I've never been asked that question before, but that's a fair question. You, basically what I tell folks, lawyers, defendants who are at liberty, if you don't have to stay here, but if you're going to go somewhere, we have to be able to contact you, and same applies for the state, so you can return within a reasonable time. I mean, like, hopefully 5,
My
10
lawyer's office is right down the street.
5-10 minutes, we have to have a phone number, and if, hey, we got a question, we got a verdict, I'll ask the bailiff, has everybody been contacted? They'll have a way to contact them, and everybody returns. So,
Yeah, I have, my lawyer's office is right down the street. You should have my they have my contact number.
well, as long as we have a number before, after the jury goes back, as long as we have a number, or we have a number that's good, I don't particularly care where it is, as long as it's good, and they're not gonna say, oh, gee whiz, he went up to Marathon or something like that, then you can return within, 5-10 minutes, that's it.
That's fine,
So,
Your Honor. I just wanted to make sure I didn't know the process.
yeah, that's fine. I mean, you don't have to stay here. There's, the jurors are gonna be in that jury room. They're gonna be under constant watch, which is the normal procedure, outside, of course. Nobody's gonna be in the jury room. And when there's something that we need to address, question, problem, verdict, everybody's contacted, and they're not brought out until we're all here.
Would you like me to leave that number now, Your Honor?
Well, whichever you prefer.
not gonna change,
If that's more convenient for you right now.
Just make sure.
We always do it after all the evidence has been checked by the.
But if he wants to give it now, if you can help with that. All right, anything else? I think we've covered it in detail.
No, sir, nothing from the state. Thank you, Judge, for your patience. These instructions are always highlighted at the trial.
I think everybody on all sides has been quite patient, so. In any event, see you tomorrow.
Thank you, Judge.
So there we have it, guys. The court is adjourned for the day. Obviously, it adjourned a little while ago. We're kind of watching this. We were watching this last hour, as I mentioned at the beginning, because my stream cut off because I was running some errands. I was out of studio. Anyways, I do that sometimes while I'm watching these, and I'll watch from my phone, or listen from my phone. But anyways, crazy instruction period there. I don't even that was nuts. But I think, in my opinion was, I don't think normally the defense attorneys are involved in this process, and normally they're working on this as a working product. days in advance, but because this was kind of sprung on them, that Tucker ended up resting earlier than expected. They were expecting to probably be going towards the end of the week when they were going to be dealing with all of this. Here we are. Ended up with a 3-hour disaster when it came to jury instructions. The interesting thing to take away from the jury instructions is all these lessers. Now, I think the state kind of brought this on themselves because at the beginning of the day, you heard the judge even acknowledge, well, what's this packet of, huge, thick packet of instructions. And they were trying to throw all these lesser included offenses and all this stuff to, I think, confuse the jury. Hold on. To, I think, confuse the jury, or not necessarily confuse the jury, but make the jury consider lesser included offenses, because I think they understand their case is pretty weak. And I think what they're hoping the jury's going to look at in this case to get any kind of conviction is they're looking for the jury to say, hey, somebody died, somebody got hurt. We can't let this man walk out of the courtroom. We think he might be involved, but we don't know how. So instead of convicting him of murder, we're convicting him of X. We're convicting him of battery, whatever. And that way he gets something and he doesn't just walk out. But I believe if the jury follows the law, there's only one verdict in this case, unfortunately, regardless of what the prosecutors want to say. And that is not guilty. And their big moment, the big moment that the state focused on today in closing arguments, was the knife, right? The blood on the knife. Well, let me play for you before we leave here. One moment. I'm going to play at the end of this, and I'm going to do a separate video, I think, on this. But I have the clip. I have the clip of the moment. I have the clip of the moment that Mr. Tucker was talking to Phelps, where the knife got brought up. Now, my first thought on that was, police commonly will lie about things, but there's also the ability to get something wrong, right? And as we know, Paula is not a very consistent individual. She said multiple things multiple times, and people hear things in a certain way. People take things in a certain way. What I'm going to show you is, do you believe you have that conversation? 10 hours later, you're standing in McDonald's. I know many other people, when I've had conversations with people, we have a tendency to embellish. We have a tendency to add things to what we've been told. We have a tendency to make an assumption. The state is trying to attach to the idea that he said there was a knife with Matt's blood on it. That means he knew that because he stabbed Matt. That's a possibility, but I don't think that's why he said that. I think he said that because when you listen to this clip, you're going to hear Captain Phelps tell him about a knife with blood on it. One would make the assumption, especially because if you recall, he had never heard, he had never heard at that point until he met Paula at McDonald's that she was stabbed in the neck. He didn't know that. He runs into her. That's why they step out. As far as he knew, it was just Matt who had gotten stabbed, and he wasn't aware of all the facts because it wasn't disclosed to him of everything that had happened. They didn't tell him all those facts. They didn't want to tell him all those facts because they commonly don't. He had just heard from someone else that somebody had been stabbed. Initially, it was up at the CVS parking lot. Then I think somebody told him something, or the police got into it and said, there was somebody that Matt died. Matt was stabbed. So as a result, when he's talking to Paula and he says the detectives told me Matt's blood was on the knife, it was a situation where he assumed that's what he saw on the knife. In other words, he was told about the blood and he kind of assumed that and filled in that blank, then communicates that to Paula, then Paula hears it and Paula regurgitates it back out. Absolutely not something that this jury should say, we're going to find this man guilty beyond a reasonable doubt. That is not evidence beyond a reasonable doubt of anything. Now, I trust that this jury, having served on a jury myself, having been a foreman of a jury myself, I trust that this jury is going to do its job. It's going to follow the law, like what happened when I served. We followed the law. We followed the judge's instructions. And I believe they're going to do that. I believe every jury is going to do that. Any jury that does this, listen, when I came into this case, I never heard about this case until last week in opening statements. And I came upon this case and started looking at it and started looking at all the evidence. So my assumptions, my presumptions, my conclusions, as I find right now, are all based on obviously what was just said in court and then what I've found since I started my investigation into this case to further investigate and realize there's some really, really, really disturbing, concerning things about this case that have happened. But anyways, without further ado, let's watch this video. Give me a moment here. Got to cue it up here. I apologize. Let me switch over. All right, sorry about the delay there, but here is the video I'm talking about here. So this is the video. This is the exact moment that he's referencing, that the state was referencing right here. We're going to listen to it together, and I want you to hear what I heard, what I was talking about here, and tell me, you take this conversation and what he hears in this conversation, and can you believe that when he's talking to someone else, talking to Paula 10 hours later, and he's embellishes a little, exaggerates, fills in the blank, or really doesn't even embellish. He just assumes that this detective is talking about Matt when she says there's blood on the knife. He says it ain't me. He's going to assume the blood on that knife would have been, of course, the victims, right? I mean, you could assume that. So it would not be some smoking gun that says, oh my God, that's because he stabbed him. Absolutely not. And you don't need DNA evidence to make that conclusion. And I agree with this statement, Mary. It is absolutely frightening, and that's what's scary about tomorrow. Because what's scary is if this DA's office gets their way tomorrow, he'll be convicted and thrown in prison for the rest of his life. I mean, that's scary as hell. That a case like this, especially when you know all of the background of this case, when you know everything that actually happened, you know everything that he wasn't allowed to talk about, that he wasn't allowed to put forth to this jury. He wasn't allowed to go into the suppression motion that should have been admitted. Should have been put before the jury that Travis Johnson had essentially said everything he testified to was a lie. Anyways, let's listen.
The text picture is absolutely accurate with the timestamp on the video.
And I want you to listen how similar
walking on 2nd Street
Phelps is and how she approaches him.
Laurel Avenue, which is the road that the Treehouse is on. 8:11 p.m. At 8:15 p.m., the first call comes into 911 telling our dispatchers that a guy has been stabbed, he's dead, and he's laying face down in a pool of blood.
Yeah, but that's what I'm saying.
Okay, just hear me out. So you have 4 minutes from where you're at to where this thing happens. Now the really disconcerting part of all of this is that 8:19, 4 minutes after we have a report of a man being killed, we have you and Rory on video walking back from the Treehouse toward...
That's got to be impossible though. Because, okay, you know, like I said, man, freaking... I wish I had Travis here because, man, again, man, go back and check the Tom Thumb video.
Okay.
Because that had to be somewhere around that same time. Had to be. You know what I'm saying? Because, man, You know, I remember, man, freaking the whole thing with the police lights and stuff like that was not long after we went and got cigarettes. So, man, freaking, man, how can I, how can I be, man, freaking a Tom Thumb buying cigarettes while I'm supposed to be over there at the CVS? You know what I'm saying? Now, I do, man, like I told him, man, freaking, I have a vague memory of, man, freaking walking through the drive-through at the CVS.
Okay.
You know, so, man, I may have gone there earlier, man, freaking, I could see that. You know, or man, but I know I didn't go there later. I know I didn't go there later, but man, freaking, I may have gone there earlier. But man, I mean, literally, check the video, man.
Okay.
Freaking.
Now, Ty, let me tell you some other things that Detective Fisher hasn't shared with you that I'm going to share with you.
Okay.
That's on our side of the story.
Okay.
In the walk from Laurel Avenue on 2nd Street to where you live, we found in lot 72 a knife.
Okay.
Okay, on that knife is blood, and on the handle of that blood, latent's DNA. That's going to the lab.
Well, it ain't gonna be me.
Okay, and a little further up the road, in the back of a boat parked alongside.
All right. So you heard it. Mystery solved here, right? What does she say there? And I'll play it back in just one more time for anybody watching this or gets this far in the video. We'll see that the statement she makes there is she's saying there's DNA on the handle that they sent into the lab, but that there's blood on the knife. Now, his assumption would be, because at that point, he wasn't told Paula was stabbed. They don't tell him that information. And I've watched the interviews, to my knowledge. He wasn't aware at that particular point. He's just being told there's blood on a knife. He knows Matt got stabbed. As you can hear, he's saying, when he gets in there, in fact, at the very beginning of this interview, when he arrives, he's like, wait a minute. All he knew, he had heard that there was a stabbing at CVS. Right near the Treehouse. So he's saying that was what he had heard originally. And, you know, to his knowledge, he never heard all the details as far as what actually happened. Now, is it, you know, when he goes and makes a statement to Paula at McDonald's and he sees she's stabbed and he realizes, oh my God, you've been stabbed, and she's telling him what's happened. His assumption is, the detective here is talking about the knife used to kill Matt. Therefore, he says the knife has got blood of Matt on there. That's how he's remembering it, because the detective here is not telling him there was multiple people stabbed at that particular point. They're not getting into the details. The reason why they're not going to get into those details is because they're withholding those details because they need to have him present those details back to them. So those details aren't being readily shared. They're not coming out and talking to him about it. They're wanting to see what he knows and see if he's willing to tell them how many people got stabbed or things of that nature, things that he should know, which he never provides. He says, I don't know anything. In fact, all I had heard up until earlier that day before you arrived, when a woman had clarified that it actually happened at the Treehouse and not at CVS, said, all I knew was I thought somebody got stabbed in the CVS parking lot. That's all I heard was a man got stabbed in CVS parking lot. So the point is, when he's making that assumption, all he's hearing about is the man. He's not hearing about Paula getting her neck cut. That's not what was being told to him originally. So when he hears that, coupled in with her throwing out that the knife is there, hey, there's a knife there with blood on it, with your DNA, with DNA on the handle that we're sending in, and she's trying to scare him into saying, hey, trying to scare him into thinking, hey, we got all this evidence and you better tell me what you know. What she's doing is the same thing she did to Travis. He was smart enough to not succumb to it, because she's lining it up and saying, we got a video of you walking, and in that walking path, we found a knife and we found a mask. You better tell us we have you on video. And he's saying, it ain't me on the video. There's no way you have a video during that time. It doesn't make sense. It doesn't make sense. And that's been his story from day one. So this smoking gun that the prosecutors tried to throw up by putting that in yesterday through the deposition and acting as if that's great. It's just like corroboration is not, because Travis told his story multiple times on multiple occasions. That is not corroboration. Okay. Just because he told his story. And if you look at the sequencing of events, Travis tells a very vague story, essentially agrees with the 6-minute recitation of events. Then they go and start watching videos. And she says, let's get together and I want you to show me and point out where Ty's at. And that's when he clarifies it's not me in the Keys Electric video. And then they pour up the Cosmo video and he says, tell me where Ty is. Tell me where Rory is. Tell me, I see your truck right there. So he watches all those videos. Now at that point, from that point on, it's no longer corroborative evidence that he tells that story in 2019. He tells that story in 2022. He tells that story on the witness stand in 2024. It's not corroboration. Corroboration would be independent witnesses that can come out and see what he's doing. Evidence like DNA evidence like fingerprints, things that are backing up a story that he's putting forth. But none of that exists. And all the eyewitnesses that this jury did not get the benefit to hear, conflict with the story that he laid out. In fact, if they put the 911 caller Gabby on, she's going to tell a story that completely sounds different than what he described. And you're going to have O'Quinn, who Mr. Tucker wanted to call, is going to tell you a story that's going to conflict. Well, so it's going to conflict. He's never going to see the truck. O'Quinn's not going to see the truck. Doesn't mean it wasn't there. Eyewitnesses only see about 30 to 40% of the events and retain that, and then it gets less and less and less. And then as they're remembering events later on, you start discussing memories with other people, and then you start remembering what you heard and this and it all. It really, that's why it's important to get that initial statement in and look at what it was before they start rethinking it over and over again in their head, which sometimes helps. But if you're rethinking it and you're talking to others, and you could start remembering events and filling in blanks and putting things that maybe weren't there because someone's telling you their perception of what happened. But the bottom line is that there is no corroboration. And the corroboration that he spent hours saying, when you have to spend an hour in your closing argument, and the only thing you're doing is reciting the testimony of your witness, the testimony of one witness, a witness you gave a deal to who faced life in prison, and that is your closing argument, and that is your case. And then you come in here with this flim flam shit with, he said there was blood on a knife that was Matt's, and then you go back and you rewatch this. They didn't even put this interview in evidence, right? Why didn't they put the interview in evidence? Why? Because they didn't want to have Ty Tucker's story in, because they knew he's telling a story of innocence. They knew they would hear he was saying he was innocent from day one, which he then got up on the witness stand and said again. They didn't want to open up the questions, not to mention the fact that this interview, when you watch it, is chopped into 37 pieces. And, it opens up doors that the prosecution didn't want to open, and it opens up questions that they didn't want being brought to this jury because they're afraid to have those questions asked in a public setting. And what we have left here is truly a disturbing picture when you have prosecutors standing up and have nothing to argue. They had nothing to argue. What you saw was a master course in prosecutors essentially trying to simply just ask a jury to convict with no evidence at all and say, listen, we have a bad case. We have an unreliable witness. We've successfully kept out any type of exculpatory evidence that would come in. We know it's there. We should be having it in. We would normally think that a trial would be a review of the facts, all facts, put it before the jury, let the jury review it, let the questions get asked. If there's a reasonable doubt, or if it becomes apparent that that maybe it's even worse than a reasonable doubt, but all you have to do is have a reasonable doubt as to the charged elements of the crime, it goes away. It's not guilty. But not in this case. Not in this case. And you have a prosecutor standing up, attacking the victim. When have you ever seen that? They're attacking a victim who came to court and they did everything in their power to try to prevent her from testifying. They didn't call her in her case, and she has now come to the conclusion and said, he didn't do this. And all he's done is insulted her because she's a crack addict, insulted her because she was homeless, and said essentially that she, because of her drug addictions and her ailments, that her testimony shouldn't be believed and she should be looked upon as somebody who is easily susceptible to being led astray by Tyrone Tucker. Yet she said from day one, you want corroboration? If corroboration is from day one, she has said it was Detroit. From day one, she said she didn't know who that other person was. From day one. And she said she was never asked if it was Ty Tucker that night because they didn't know who Ty Tucker was. But when they started bringing Ty Tucker up, she said consistently, and you haven't seen the Pitcher interviews when Pitcher is in the car with her, you haven't seen what Ty Tucker wanted to bring in. Because, see, they brought that deposition in, and they said, oh, question her. She's unreliable. She was unreliable because she had a detective. And many people, and with good reason, put a lot of weight behind when a detective is telling you something. And this detective, even though she would continuously say in these statements to him, which were not allowed to come in, I don't believe it's Ty. I don't believe this is before Ty was. This is why Ty was in jail. It wasn't Ty. I don't believe it was Ty. And he'd say, you don't know. You don't know. You don't know what we have. You don't know what we have. Once you see this stuff, go to freefranklintucker.com. You can go in and look at a plethora of videos. Watch them. Watch the body cam. It's all there. It's not altered or anything. It's there as it came out of the file. Go check it out for yourself. Go to the Monroe County Clerk's Office online, and the entire case file's there for all of these people. You can go in, you can see their pleadings, you can see their motions, you can see all the stuff. It's all there for the public consumption. You can go in and do your own research on this if you don't believe it. But when you start doing it, you're going to be shocked at what you find. Because what you're going to find out is we don't know why they went after Ty Tucker. My theory on it is it was to cover up their own incompetence. They went down a road. They thought he was the guy because of the Facebook picture. They start going in the fact that he was there with Rory Wilson at Metro PCS. Listen. If you go in there, as I brought out in the video, there was a personal relationship, we'll say, between Malone and Phelps, meaning there was at least emotional feelings about each other, meaning they don't want to see anything bad happen to each other. And as a result, they didn't want to say they were wrong. And if you get to kind of understand Penny Phelps as well, what we didn't get deep into, but when you picture, they were talking to her, I said, what's Penny Phelps' reputation? Her reputation is she's a hard-nosed person. She's a very overbearing person. She is someone who doesn't admit she's wrong very well. So for her to have had to stand there in front of her investigators in a case that she gets involved in, again, one of the key questions in this case is, why was Dunn at the crime scene before the lead detective? Why are they already there? Why did they take over this crime scene, which in Pitcher's own words was not the usual? It was not common for that to happen. What's going on there? We don't know. What we do know is they don't follow the lead of Anathea Clay, to which the state wants to say, oh, that's nothing. That's you do. Who cares about that? There was no evidence. There was evidence. And here's the contrast. Anathea Clay, there's no evidence, right? So they disregard her to the point that they have her at the scene. They don't bring her downtown like they did Ty Tucker. No, nothing, right? But Ty Tucker, there's no evidence. There's no DNA. There's no fingerprints. There's not even one witness that has brought up his name. He walks into Metro BCS. He pays a phone bill with Rory Wilson 3 days after the incident. And that's enough evidence for them to drag him out of his house where he's staying in handcuffs in a raid with pointed gun in his face, and then take him down to an interrogation room and say, hey, you're the guy. You're the guy. Paying a phone bill and looking at a Facebook account. That's all they needed. That's their level of evidence. But you have Anathea Clay being her name is in the mouth of the victim in this case. Okay. They're willing to drag a man in for questioning over a Facebook photo and a phone bill, but you got somebody saying Anathea Clay did this, she planned this, and that lady hasn't been put in the thing, and they tried to poo-poo that off in court. And the state tries to say, oh, he makes a big deal about it. But there wasn't. What are you talking about? The contrast there is ridiculous. How do you explain that? There isn't an explanation for that. It can't be explained. It's ridiculous. But what it tells you is there's something wrong. There's something wrong with this picture. There's a reason why they don't want Anthea Clay to get in trouble. They covered for her. We don't know why. Was she a confidential informant? We know her number was in, according to picture. A police officer had her number in the phone. He couldn't remember which officer it was, but they got her there. There's an interview that was, I think, 30 or 40 minutes, and there's only a minute and 30 seconds left of that interview. There's tapes that were destroyed, according to Mr. Pitcher. Mr. Pitcher had a Tom Thumb video. Listen, understand this. The Tom Thumb video, what you heard in there, you heard Tucker talking about Tom Thumb. Tom Thumb is his alibi, okay? Now, I want you to understand the significance of this. Tom Thumb has a lot of different pieces, the Tom Thumb store. One of the pieces is directly after the crime, Michael Alexander says he saw a guy who was leaving the treehouse come over to Tom Thumb with blood on a sweatshirt that was never recovered, thrown in a trash can. He leaves, gets in a silver car, and drives off, right? And he said he recognized this guy. This guy was a regular over there at the treehouse. But he says he comes over and he tried to give him this sweatshirt. Police were supposed to be getting video to check out who that was. In addition, when they talked to Ty Tucker, when Phelps was talking to Ty Tucker, he's telling him, get the Tom Thumb video. Because what he says is that he went and walked to Tom Thumb getting cigarettes, and that he should have been on that video. That would have given a timestamp of when he went and when he walked back away. Well, guess what? That video got destroyed as well. Well, not so much as destroyed as they claim they got the wrong date. That video, which could have established and cleared up exactly when Ty Tucker went to go buy cigarettes that night, and could have very well been a clear, convincing evidence that he had nothing to do with this, and it mysteriously got destroyed. Why do you think that is? I don't know. I'm not going to conclude why that is, but I want to say it's a little bit suspicious, isn't it? It's a little bit suspicious. Could it have been that confirmed his story, and Phelps said, nope, we can't have that because I've already gone down this road. So, it gets destroyed. And then they just simply say, well, we got the wrong day. Sorry, we don't have that. Because everything that didn't fit their story is gone now. And you saw what that ended up amounting to. When they couldn't get a CI into court because they got caught lying to the court about how the entirety of the situation went down, and he eventually was unable to be used because they found out that after they held out to the court that the CI wasn't paid, wasn't a known CI who had come in and snitched on others before, and wasn't working with any detectives, wasn't affiliated with any detectives. He was just a concerned prisoner in the local jail. I happened to hear Ty Tucker talk about the fact that he participated in this murder, even after Ty Tucker's telling everyone and their mother, phone calls and everything. Nope. Never a word, but he allegedly talks to this individual. Of course, it sounds suspect, and it ended up being suspect. And I'm bringing this up because everyone wants to question Ty Tucker. Everyone wants to say all these things didn't happen, but you don't look at what has happened. Because I guarantee you, if that guy would have testified in this court and he would have raised it and said he's lying, there would have been a bunch of people that would have said, no, he couldn't have been lying. No, why would he say it? Why would he lie? Why would he do this? Prosecution wouldn't do that. Where's the proof that they did that? Well, guess what? Luckily, we never got there. That person never made it in because it became clear when Colleen Dunn held out to the court at Mr. Tucker's Arthur hearing that this individual had no affiliation with the police, had nothing to do with the police, and was just simply a concerned citizen. And then it came out that wasn't true, that yes, he was a paid confidential informant, or he was paid as a confidential informant for his actions. And that not only was he paid money, but he was also released from jail in response for being willing to come forward and say he heard Ty Tucker confess. And on top of that, they were able to prove through the records at the jail that he was moved all around the jail, moved to places where Ty Tucker was, moved to places where Rory Wilson was. They were moving him around. And of course, it's been established and testified to in court documents that Colleen Dunn was known for. It had been a well-known method of her to bolster and help her cases with jailhouse snitches. But that got proven. They had to admit that that was all. And again, they got emails and they got different things. There's different pieces of evidence that are in the file. There's a motion I'm going to present for that to on another presentation that will blow your mind when you see everything that's related to that. It's all part of the court record. And they lied there. So if they will lie at that, if they will do those things, and you can confirm everything I'm saying, go to the Monroe County Clerk of Court's office, look up Franklin Tyrone Tucker, go in. There's 700, I think, and 75 documents. Go in there and do your own investigation. Confirm what I'm telling you. And when you go in there, you will be as shocked and as outraged as I am and disturbed by the events. And if this goes wrong tomorrow, if he gets convicted tomorrow, you'll understand the outrage that I'll be expressing, openly expressing over what happened and occurred. Because fact of the matter is, it's very, very, very likely, and nothing's 100%, but it's very, very, very likely in this case that we can say with great confidence that Ty Tucker, if he gets convicted tomorrow, is an innocent man going to prison. And we can only help or hope that those 12 individuals see things like we have, and that they saw enough, that he did enough, that he talked to them, that they look at this case and they saw the little nuggets he was able to drop, that they understood when the judge was referencing things and they say, you can't consider that in record, that they just understand that there's something wrong here. That there's something wrong here when they get a case and there's only one piece of evidence in that case, and that is a witness who was facing life in prison, was given a 5-year deal to get out of prison, and that's the only evidence that they have. There's a problem. There's a big problem when that's the only evidence that the state has. In the DNA, nothing. The closest thing they have to an eyewitness is Roger Ruggett, who says, I don't know who it was. He was the same height. Well, guess what? So the jury got the opportunity to see both Travis, as we did, and Ty Tucker, and they're very similar in height. I think Travis is a little skinnier than Ty Tucker, but similar in height. So that's nothing. That sure as heck is not proof beyond a reasonable doubt. Just like inconclusive. Again, I understand Ty Tucker doesn't want to go to the jury, didn't want to go to the jury, and he didn't have lawyers in there to argue the nuances of the law. But when you have the presumption of innocence in place, and you're starting your journey from innocent, and you're requiring that the presumption of innocence be overcome by the prosecutors, then things like inconclusive break for Ty Tucker. In other words, when you're presuming innocence and they come to you and they say there's a lab report here and it's come back inconclusive, that means we presume it is that we don't do what Prosecutor Mansfield suggested, which he got away with because there wasn't an experienced attorney on the other side. No, we presume innocence. We presume the inconclusive leans towards innocence. There isn't an inconclusive result that leans towards guilty. That's not how our justice system works. So when you put the DNA in its place, innocence, we presume innocence off of that. Roger Ruggett, not sure, similar in height. Well, Travis Johnson, similar in height. The tie break, presume innocence. That's how we do it. When you're looking at Travis Johnson's credibility and you look at what he has, you have to use the presumption of innocence when you're doing your analysis of that testimony. And you have to analyze it from that perspective. And when you look at it and you look at the credibility issues and you look at what he has to gain and you look at all of this and you go, okay, I got doubts, right? Strong doubts. Well, what else is there? Problem is there's nothing else. There's nothing else. So that jury's literally sitting there with nothing else. So then you go, wait a minute, is there any conflicting testimony? Is there a conflict of testimony? Yes, there is. There's a conflict of testimony from the standpoint of you got Ty Tucker who decided to testify. And if you find both are just as reasonable to have occurred, that there's two likely theories, one of innocence, one of guilt, and you're not sure, and you're vacillating, you're wavering, you break towards innocence. When you apply that standard to this case, not guilty is the only way this thing comes out. Unless the prosecutor, as Mansfield said in court, we have the unique, this case is so unique, we want to preserve the record because we have this unique opportunity we're never going to get again. Because he knows if Mr. Tucker were to get convicted, attorneys are going to get involved. And if another trial happened down the road, attorneys would most definitely be involved in this case. And he doesn't want to give that opportunity because he knows he's getting the opportunity to argue things, present things, and do things in this case that would never happen if a skilled attorney. Now, I understand. No one is asking, nor has Ty Tucker has at any point asked anyone to say, feel bad for me, I don't have an attorney. It's a choice he made. I'm just stating that if this is applied correctly, if these arguments were made correctly, this is a slam dunk. But everything that's been presented. Mansfield doesn't get away with what he did when he was making his arguments today. But the question is now, of course, the arguments that were made on both sides, the arguments that were made by Mansfield, that were made by Ty, where does it land? Is it enough? I think it is, because I believe when this jury gets back there and they hear the judge's instructions and they're listening and they hear about reasonable doubt and they go back there like anybody would, conscientious jurors wanting to do their job correctly, and they look at this case, I don't see how 12 people are going to sit in that jury room and go, let's break down this case. There's going to be a conflict of evidence. There's going to be doubts. I mean, it's a mess, and it's a complete mess. And I think this jury's going to have that feeling. And I think this jury's going to say, listen, we got a guy one guy's already been convicted. He's away. I don't know if they know that, but they might know that. Might have been able to assume that. And then you got Travis, who it was put before the court. He's out. I don't think they're going to have this, and you've got a victim that says it's not Ty Tucker. I don't think you're going to have this jury sitting there thinking like, well, we got to hold someone accountable. Someone's been held accountable. The state screwed up this investigation. Ty Tucker's had 6 years of his life held up, and it's a mess. Not guilty. Even if somebody suspects that he might have been there, there's just not enough proof to go guilty on any of the charges, in my opinion. And that's what I think we'll have. I hope we'll have. That's what justice looks like in this case. Anyways, we're going to conclude it. I wanted to get into that since it is closing day, since we did close and the case is over. We'll be back tomorrow to hear the jury's charge, and then we'll be monitoring for a verdict tomorrow. See, I hope it's a quick verdict of not guilty, and we'll go from there. And then I know there's several other cases going, and we'll see if we can we'll probably start covering some other cases as well. Like I said, there's plenty more I intend to report on this case. There's just an enormous amount of things that need to come out that were not in this presented here that will continue to be relevant to this situation, especially depending on the outcome. The story needs to continue to be told, and it will be told. Anyways, that's where we're going to leave it. And until we talk again, guys, let justice prevail, and I'll talk to you soon.